Welcome to VSOW. Today we're embarking on a really vital deep dive. We're tackling one of the most intensely debated topics in American civic life, those often fraught interactions between police officers and citizens.
That's right. And we've really synthesized a robust stack of sources here: legal analysis, policy critiques, training manuals, even some tragic case studies.
Our goal really is to provide you, the listener, with the most precise and frankly actionable knowledge we can pull from these materials.
Yeah.
We're talking about accountability, use of force, and crucially, your rights during an encounter.
Exactly. Our mission here is to try and move past the loud rhetoric and really ground ourselves in the facts. We're looking directly at the core dilemma. How do we reconcile the need for effective law enforcement with protecting fundamental civilian rights?
It's a tough balance.
It really is. And the sources, they clearly show that millions of these police-citizen interactions happen every year. And, well, many of the most tragic outcomes, they don't always stem from officers facing, overwhelming immediate threats.
All right, sometimes it's more about preventable failures.
Often, yes. Failures of policy, failures in training, breakdowns in communication, that's what we see again and again in the material.
So that's the tension we really need to unpack today. The path towards safer interactions, at least as illuminated by our sources, seems to require reforms happening at the same time.
Right, on two levels.
You've got the institutional level, things like department oversight, better training, and then you have the individual level. That means, a heightened awareness among civilians about where the constitutional boundaries actually lie.
So we've broken this deep dive down systematically. First, we'll tackle the institutional bedrock, looking at the need for meaningful systemic accountability, real oversight.
Okay.
Second, we'll move into officer training, focusing on what many sources call a non-negotiable shift towards de-escalation techniques.
Makes sense.
Third, we want to empower you with the Civilian's legal toolkit, understanding your rights to record, maybe even resist in very specific circumstances, and definitely to remain silent.
And finally,
We'll dig into some specific, real-world case studies, examples where de-escalation unfortunately failed, often with devastating consequences.
okay, sounds like a comprehensive plan. Let's start at the top then, with that foundation of trust, systemic accountability, and the role of independent civilian oversight.
Yeah, so a key finding, especially looking at materials like those from Justice Forward Virginia, is that in far too many places, law enforcement seems to operate under what they call a shroud of secrecy.
A shroud of secrecy, that sounds problematic.
It is, because it's not just inconvenient, right? It actively limits democratic accountability. If the public or even their elected representatives can't get the necessary facts, how can they fairly evaluate police performance?
And the result, I gather, is that these civilian oversight bodies, or COBs, they often exist on paper but lack any real power.
Precisely. They might be there, but state law often ties their hands. They can't easily access key evidence like personnel files or raw use of force data or internal investigation notes. Sometimes they don't even have the authority to compel testimony, interview witnesses under oath.
So, if the reviewers can't get the information they need, the whole process feels a bit, well, performative, as some critics say.
Exactly. It looks like oversight, but doesn't function like it. So, to get from performance to actual function, meaningful oversight needs some specific qualities. The first one highlighted is being proactive.
Proactive, meaning not just waiting for something bad to happen.
Right. Your traditional civilian review boards, or CRBs, they often fall short because they're purely reactive. They only look at complaints after someone alleges misconduct and, files the paperwork.
Okay, so a proactive body would do what instead?
Yeah.
Look for patterns.
Yes, exactly. Look at patterns, not just isolated incidents. This means doing independent analysis of comprehensive police data, every single use of force report, stop and frisk statistics, looking at demographic data around traffic stops.
So digging into the numbers themselves.
And also conducting policy reviews, maybe even financial auditing. Are resources being allocated properly? Are there systemic issues, like, say, implicit bias showing up in the data? The idea is to catch these things before they generate a stream of individual complaints.
That's like fixing the system, not just chasing after individual officers.
That's the idea, shifting from bad apples to fixing the barrel itself.
Okay, that makes sense. What's next for meaningful oversight?
Independence. This is non-negotiable, according to the sources like NACOL, the National Association for Civilian Oversight.
Independent from the police department they oversee. Seems obvious, but I guess it's not always the case.
It's a major sticking point. Nicole strongly advises against letting the chief of police or other high-ranking department officials appoint the board members. That kind of direct connection just undermines any claim to real independence from the get-go.
Right. You can't oversee someone who appointed you effectively.
It creates an impossible conflict. And if they are independent, they also have to be empowered. They need what the sources consistently call real teeth.
Real teeth. Okay, that's probably the most crucial missing piece in many existing models, right? What does that mean in practical terms?
It means the power to compel information, first and foremost. Subpoena power for documents, internal records, witnesses is absolutely essential. Without it, the COB is just relying on the goodwill of the very department it's supposed to be investigating.
Which kind of defeats the purpose.
Completely. And beyond that, the most truly empowered models actually grant the civilian board the ability to make final, binding decisions on officer discipline in certain specific cases.
So the department can't just ignore their findings if they don't like them.
Exactly. It prevents the department from simply overriding a finding of misconduct after the board has done its work.
So we're definitely talking about moving way beyond that old model of the Civilian Review Board, which was often just advisory.
Miles beyond. Those often just made recommendations that the chief could, frankly, take or leave. The goal here is a genuine democratic check on police power.
And transparency ties into this too, I imagine.
Absolutely. Transparency is the lubricant for this whole system. All operations, meetings, the data they analyze, their final reports, it all needs to be public. Legitimacy is built when the community can actually see the process working openly, even when the outcomes are complicated or maybe controversial.
Okay, proactive, independent, empowered, transparent. What about the structure itself? The sources seem to argue it needs to be local and community-driven. Why not just have one statewide body handle everything?
Because policing isn't uniform, right? Patterns of interaction, the history between police and community, they vary hugely from city to city, sometimes even neighborhood to neighborhood within a city. So oversight needs to be individualized for each locality. And crucially, the board's composition needs to reflect the communities most impacted by local policing. A board member from, say, a wealthy low-crime suburb might have a very different perspective, maybe an insufficient one, compared to someone from a community with a history of high stop-and-frisk rates, for example.
Representation matters.
Yeah.
And finally, let's touch on the practical side. Funding. These boards are sometimes set up as volunteer operations. Is that sustainable?
The sources suggest it's a major failure point right from the start. Meaningful, data-driven oversight requires real expertise investigators, data analysts, auditors, maybe legal counsel, administrative staff.
It's a professional job, really.
It is. If the board is purely volunteer-based, how can it possibly have the resources to effectively scrutinize a professional, well-funded police department? Municipalities need to see this as a critical investment in public trust, not just a volunteer committee. Financial and administrative support is vital.
Okay, so summing up this section, real accountability hinges on oversight that's independent, truly empowered with tools like subpoena power, adequately funded, and proactively looking at the big picture, not just reacting to single incidents. All right, so if systemic accountability provides the necessary structure, then training is about the procedure, what actually happens on the street. Let's shift now to that critical moment where an officer has to decide whether or not to use force. There are a couple of key Supreme Court rulings guiding this, right?
Yes, two landmark cases. The first is Tennessee v. Garner. This set a pretty high bar for using deadly force, specifically against a fleeing suspect.
What did it say exactly?
Basically, the court mandated that deadly force can only be used if the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury, either to the officer or to others. Just running away isn't enough justification for deadly force.
Okay, that's Garner. What's the second one?
The second, and maybe even more pervasive standard, comes from Graham v. Connor. This case established that all uses of force, deadly or not, have to be analyzed under a standard of objective reasonableness.
Objective reasonableness. That sounds like a critical legal concept we should probably spend a minute on.
It really is. Objective reasonableness means the officer's actions have to be judged from the perspective of a reasonable officer on the scene at that moment, not with the benefit of 20/20 hindsight.
So considering the chaos and uncertainty of the situation.
Exactly. The sources emphasize how fluid, uncertain, and rapidly evolving these moments can be. So the court asks, Was the officer's response reasonable given the totality of the circumstances at that exact moment they had to make the decision?
So let me get this straight. If the officer's belief was reasonable then, it doesn't matter if later facts show something different. Like, if what they thought was a weapon turned out to be, say, a cell phone.
Precisely. If the belief was objectively reasonable in that split second, the use of force might still be considered legally justified under Graham. And this is why organizations like the Police Executive Research Forum, or PERF, talk about these encounters that are lawful but awful.
Lawful but awful. Explain that.
These are incidents where an officer, maybe acting under immense pressure, had a solid legal defense for using force. It met the Graham standard, but the fatality, the awful outcome, could potentially have been avoided altogether if different tactics had been used, maybe creating distance, using time differently.
So legally defensible, but still tragic and perhaps preventable.
Exactly. And the existence of these lawful but awful shootings is really the driving force behind this big push for mandatory de-escalation training.
Which brings us to that shocking data you mentioned earlier about the imbalance in training hours.
Yeah, PRF surveyed, I think it was over 280 police agencies. And the numbers, well, they tell a pretty clear story about historical priorities.
Yeah.
The median amount of time dedicated to de-escalation training across all those agencies, just 8 hours.
8 hours. That's incredibly low, especially when you compare it.
Compared to a median of 58 hours on firearms training and 49 hours on defensive tactics.
Wow. So basically, officers were getting trained about 7 times longer on how to shoot than on how to avoid shooting in the first place through communication and tactics.
That imbalance really reflects an older training philosophy, maybe an informal doctrine, that often prioritized immediate physical response. You know, for years, training sometimes centered around concepts like the 21-foot rule.
Yes, the idea that if someone with a knife gets within 21 feet.
It became shorthand in some training circles for justifying deadly force almost automatically once that distance was breached. De-escalation training fundamentally challenges that mindset. It pushes a paradigm shift from win the fight immediately to something more like slow the action down.
Okay, so what does de-escalation actually involve in practice? It's more than just talking nicely.
Right. Oh, much more. It's formally defined as things like slowing down, calming tense situations, using communication, empathy, and importantly, sound officer safety tactics, all aimed at generating voluntary compliance. The ultimate goal is a harm-free end to the encounter, even if that means it takes significantly more time.
Can you walk us through some specific techniques mentioned in the sources?
Sure. The training is pretty multifaceted. First, it involves teaching officers to recognize hostility, not just in words, but in body language, and understanding the physiological changes, the stress response, fight or flight, both in the civilian and in themselves.
Self-awareness is key then.
Absolutely. They're taught things like verbal judo, avoiding negative communication like sarcasm, threats, or commands that are really ambiguous. Instead, they're encouraged to redirect thought processes through positive, clear instructions rather than getting drawn into a battle of wills.
The sources also seem to really praise reality-based simulations. Why are those considered so much more effective than just sitting in a classroom?
Because they replicate stress. They put officers under pressure in a controlled environment. One example described involved a scenario in Las Vegas, officers entering a dark, chaotic room, maybe strobe lights, loud alarms, simulating a burglary in progress.
Intense.
Right. And the focus isn't just on whether they catch the suspect, but how they did it. How effectively did they use verbal commands? Did they create distance? Did they use time to their advantage to avoid using force? These simulations force officers to practice patience under pressure, which is exactly what's needed on the street.
Makes sense.
Yeah.
Let's look at some departments that have actually implemented these kinds of changes. Dallas seems to be a notable example.
Yeah, Dallas has been highlighted as a leader in this PERF-driven movement. They really emphasize instructing officers to slow the action down, to actually stop and discuss strategy with partners before engaging in a really tense situation.
Taking a moment to think.
Exactly. Prioritizing things like taking cover, waiting for backup, rather than feeling like one officer has to immediately resolve overwhelming chaos alone. And the results were pretty striking. A reported 64% drop in excessive force complaints between 2009 and 2014.
That's significant. And the NYPD also revised its training, didn't they? Particularly after Ferguson.
They did, adding significant de-escalation components. And again, that change seemed to correlate with a tangible impact. They reported a historic low of just 67 police weapon discharges in 2015.
Las Vegas, too, driven by a DOJ investigation.
Right. They had a terrible year in 2010. I think it was 25 officer-involved shootings. The DOJ came in. They adopted something like 75 recommendations, heavily focused on de-escalation and reality-based training. And subsequently, they saw a significant and sustained drop in shootings.
But it's not always a clear success story, is it? Cincinnati is mentioned as having mixed results.
That's an important counterpoint. Cincinnati apparently tried to weave de-escalation into recruit training, focusing heavily on word choice, trying to prevent immediate defensiveness from civilians.
How so? What kind of word choice?
Well, for instance, instead of asking that classic confrontational question, do you know why I stopped you? Which often puts people on edge, immediately they coached officers to state the reason clearly and upfront. I stopped you because you ran a red light 2 blocks back. The idea is that clarity reduces defensiveness.
Okay, that seems logical. But you said mixed results.
Well, despite focusing on word choice and verbal techniques, the sources note that Cincinnati saw a drastic increase in police shootings in early 2017.
So does that suggest that just focusing on the verbal side isn't enough? Maybe other factors are at play? Or maybe the tactical side wasn't emphasized enough?
It absolutely raises that critical question. It implies that while verbal skills are essential, they probably need to be paired with that tactical commitment we see emphasized elsewhere, places like Seattle, LAPD, Chicago. The commitment to time, distance, and cover concealment.
So talking calmly is good, but if you're still rushing into close quarters without a plan?
The training might be undermined. The successful model seemed to mandate physical prudence alongside the verbal skills.
And the LAPD specifically took steps to institutionalize this.
Yes, they made it a policy requirement to evaluate whether de-escalation tactics were used or could have been used in all use of force reviews. It stopped being just a suggestion. Failure to use available de-escalation techniques became a potential policy violation.
So it had actual consequences within the department.
Right. This holistic approach using time, maintaining distance, calling for backup, that seems to be the core tactical solution presented across the most effective programs described in our sources.
Okay, so if the officer's job involves maintaining safety through prudence and de-escalation, the civilian's role involves maintaining their own safety, partly through understanding their legal boundaries. Let's turn now to what we're calling the civilian's legal toolkit, starting with the power of the camera.
Absolutely. The First Amendment right to film or photograph police officers while they're performing their official duties in public spaces is increasingly seen as a fundamental check on authority.
And this is legally established.
It's explicitly recognized in multiple federal circuit courts. While the Supreme Court hasn't given a definitive ruling on it nationwide, the First Circuit, for example, established this right very clearly back in 2011 in a case called Glick v. Cuniff.
And why is this considered so important, this video evidence?
Well, it's often described as a critical check and balance. Think about it. Without video, an encounter often boils down to he said, she said, right. And historically, the officer's account often carries more weight. Video provides, ideally, an independent, objective record, less prone to faulty memory or bias.
Okay, but there are practical considerations.
Yeah.
What's the guidance for civilians who choose to record?
Guidance from groups like the ACLU emphasizes recording from a safe distance. And crucially, you must not interfere with what the officers are doing. You can't obstruct an investigation. You can't physically get in the way of an arrest while you're filming.
What if an officer tells you to stop recording, or worse, tries to take your phone or camera?
Legally, the sources are quite clear. Officers generally cannot confiscate your device, demand to view your footage, or delete anything without a warrant. Doing so would likely be a Fourth Amendment violation and unlawful seizure.
But there's a but, isn't there?
There's a harsh reality. The civilian on the spot has to make a difficult calculation, weigh the personal risk of being potentially unlawfully arrested right then and there against the long-term value of capturing that footage. It's often a tense, split-second decision: preserve the evidence or avoid an immediate, potentially illegal confrontation and detention.
That's a tough spot to be in. Okay, let's move to maybe the most complex and honestly counterintuitive right: the right to resist arrest. We usually hear you should never resist, even if you think the arrest is unfair. But the sources, particularly looking at New York law, show a nuance here.
That general advice, don't resist, is largely sound advice for practical reasons. And legally, in New York, Penal Law Section 205.30 makes resisting a lawful arrest a misdemeanor. Furthermore, Section 35.27 generally bars using physical force to resist any arrest, whether you think it's authorized or not. The law wants to prevent street brawls over the validity of the initial charge.
Okay, that sounds like a blanket prohibition, but you said there's a nuance, an exception.
Yes, there's a crucial statutory defense found in Penal Law, Section 35.15. This section provides a defense for using physical force upon another person when, and to the extent he or she reasonably believes such to be necessary to defend himself from what they reasonably believe is unlawful physical force. It's the basic right to self-defense.
And courts have upheld this in the context of arrests.
Yes, key cases like People v. Stevenson and People v. Sansa confirmed this principle. They clarified that while you can't fight the arrest itself, a citizen may use reasonable force in self-defense if the force being used by the police during the arrest is excessive or unlawful.
Okay, let's make this distinction absolutely crystal clear, because this is where it gets tricky, but potentially very important. What's the difference between resisting the arrest itself versus resisting excessive force during the arrest?
Right. Let's use an example. Imagine an officer has probable cause, maybe lawful grounds, to arrest you for, say, jaywalking. If you shove the officer and try to run away because you think jaywalking is a dumb reason to be arrested, you are resisting the validity or the fact of the arrest. That's illegal under Section 35.27. However, let's say during that same jaywalking arrest, the officer, without any provocation from you, suddenly slams your head against the patrol car or starts using force that's clearly unnecessary and excessive for the situation. Then, according to Section 35.15 and those court cases, the law acknowledges you have a right to use reasonable proportional force solely to defend yourself against that specific instance of excessive force.
So the law aims to stop arguments about why you're being arrested, but it doesn't require you to just passively accept an unjustified beating while being arrested. That is a massive distinction.
It's the difference between challenging the legal basis for the arrest versus protecting your physical safety from unlawful violence during the arrest. The right to protect yourself from excessive force remains as long as your defensive force is reasonable and necessary in the circumstances.
Fascinating. Okay, moving on to the Fifth Amendment. The right to remain silent. Probably the most famous right, thanks to TV. What's the best practice for actually invoking it if you're detained?
Simplicity and clarity are absolutely key here. Our sources consistently recommend a direct and unambiguous statement, something like, I am invoking my Fifth and Sixth Amendment rights. I will remain silent until I have spoken with my attorney.
Saying both Fifth and Sixth.
Yes. Fifth for self-incrimination, Sixth for the right to counsel. It covers the bases clearly and leaves no room for misinterpretation that you might be willing to talk about some things.
And what's the practical effect of saying that? What does invoking silence actually do for you?
In a criminal trial, the most crucial effect is that your silence cannot be used against you. The prosecutor can't stand up and argue to the jury, well, they refused to answer questions, so they must be guilty. That's constitutionally forbidden.
Okay, but you mentioned earlier there's a difference in civil cases.
Right. This is a critical distinction people need to understand. In civil lawsuits, think asset forfeiture cases, or if you're suing the police for civil rights violations, the rules can be different. In many civil contexts, a judge or jury may be allowed to draw an adverse inference from your refusal to testify.
Meaning they can assume your silence means the truth would hurt your case.
Essentially, yes. They might infer that the reason you won't answer is because the truthful answer would be unfavorable to you in that civil matter. So it's a complex calculation. But even with that civil caveat, the immediate protection your silence offers in the criminal context makes invoking the right almost always the recommended course of action when detained or arrested.
Good to know. Finally, let's tackle the most frequent interaction, the traffic stop. You said these account for something like, what, over 30 million involuntary police contacts a year?
Yeah, the numbers are huge. Traffic stops are ground zero for a lot of friction, and much of it stems from civilian misunderstanding of the Fourth Amendment in that specific context.
What's the core misunderstanding?
Many people mistakenly believe their car is like their home, a private sanctuary where they have full privacy protection. They see it as their personal effect under the Fourth Amendment, and they think an officer needs a really strong reason to intrude or order them around.
And when an officer gives an order they perceive as intrusive.
Exactly. The civilian might misinterpret a lawful order as a violation of their rights, which can then lead straight back to that battle of wills we talked about earlier, escalating things unnecessarily.
And the Supreme Court case that really clarifies this, or perhaps shatters that misconception, is Pennsylvania v. Mims.
That's the one. Mims is crucial for anyone who drives a car to understand. The Supreme Court held that an officer ordering a driver to get out of their car, Even during a stop for a very minor traffic violation, like an expired registration sticker, is per se lawful. It's automatically considered reasonable.
Automatically. Why?
The court explicitly weighed the driver's personal liberty interest against the need for officer safety. They concluded that officer safety is such a legitimate and weighty concern in any traffic stop, given the potential dangers, that it outweighs what they termed the mere inconvenience to the driver of having to step out of the vehicle.
So the officer doesn't need separate suspicion that the driver is dangerous or armed to issue that command? Just the fact that it's a traffic stop is enough.
Correct. Under MIMS, the order to exit the vehicle is lawful simply because it enhances officer safety. And because the command itself is lawful, refusing to comply with that order gives the officer immediate, independent grounds to potentially escalate the situation, maybe use force to remove you, or even arrest you for obstruction or failure to obey.
Wow. Understanding that one point of law seems absolutely critical for civilians to avoid accidentally escalating a routine stop.
It really is. When a civilian genuinely believes they have a right to refuse that lawful order, a right they do not possess, the situation can deteriorate incredibly quickly. The officer perceives defiance, maybe a potential threat, and is legally justified in using more authority or force to gain compliance with the lawful command. It's a major flashpoint rooted in a misunderstanding of the law.
All right, let's take these concepts we've discussed, the training issues, the legal flashpoints like MIMS, the importance of de-escalation, and see how they play out in real life, specifically when things go wrong. We're going to look at two tragic encounters where de-escalation clearly failed.
Yes, the first case, Sandra Bland in Texas in July 2015, is frequently cited. It's almost become a textbook example of how a very mundane traffic stop failing to signal a lane change can spiral completely out of control.
Okay, so the initial stop itself was for a minor infraction. Was it lawful up to a point? Where did things start to go off the rails professionally?
The initial start for the traffic violation was lawful, yes, but the situation deteriorated almost immediately. The flashpoint, according to reports and analysis, was when the trooper, Brian Encinia, ordered Bland to extinguish her cigarette while she was still sitting in her own car.
And she questioned that command.
She reportedly asked something like, "Why do I have to put out my cigarette in my own car?" And that question, that challenge, seems to have been the trigger. It ignited what experts described as a battle of wills. Encinia appeared to react emotionally, perhaps seeing it as a direct challenge to his authority rather than just a question.
So instead of addressing the question or just moving on, he escalated.
The escalation was incredibly swift. After the cigarette refusal, he immediately ordered her out of the car. Now, legally, under MIMS, he could lawfully order her out for officer safety reasons. However, many experts analyzing the incident felt that ordering her out specifically in retaliation for refusing the cigarette command was problematic. If the order wasn't for safety but purely as punishment for her questioning him, that could potentially cross into violating her First Amendment rights regarding speech or protest.
And his language escalated quickly too, didn't it?
Reportedly, yes. He threatened her, saying something like, "I will light you up," with his taser, before physically reaching in and trying to pull her from the vehicle.
This seems like a textbook failure of de-escalation.
Absolutely. Sandra Bland was clearly agitated. She was challenging his commands, but based on the available information, she wasn't posing an immediate lethal threat or a serious physical danger at that moment. Experts reviewing the case concluded Encinia had several opportunities to de-escalate.
What could he have done differently?
The simplest, most tactically sound options, given the rising tension, would have been things like maintain distance, perhaps step back, use reflective listening, acknowledge her frustration without necessarily agreeing, maybe try changing the subject briefly, or, very simply, call for backup and just wait. Allow time for the situation to naturally cool down instead of forcing an immediate confrontation.
But instead, his emotional reaction to having his authority questioned seems to have driven the interaction.
It appears that way. What should have been handled as a minor conflict, a disagreement over a cigarette, escalated directly into a physical struggle, an excessive use of force during the removal and arrest, which then tragically led to her death in custody days later.
A truly awful outcome from such a minor initial infraction. Let's look at the second case study. James Barker in Salt Lake City, January 2015. This involved soliciting work, right?
Yes, Barker was approached by an officer because he was reportedly soliciting work offering to shovel snow for cash in a neighborhood where, ironically, there wasn't much snow on the ground at the time.
And Barker reacted defensively.
He became confrontational almost immediately. He refused to provide identification and started shouting at the officer, things like, "Go back to your car, I'm doing my business."
So clear signs of agitation and stress there.
Definitely. And the analysis by use of force experts highlighted that the officer seemed to fail to recognize just how stressed Barker obviously was. Anger, confrontation, as we discuss with training, often narrows a person's cognitive scope. It makes them less capable of rational thought, less receptive to calm communication. The goal of de-escalation in that moment should have been to try and widen that scope back out.
How? By giving him space and time.
Exactly, providing time and distance, but the officer reportedly did the opposite.
How so? What was the critical error?
According to the analysis, the critical failure point was when the officer apparently rushed towards Barker and physically reached for Barker's snow shovel instead of maintaining distance and using verbal commands, like asking him to put the shovel down.
Why was grabbing the shovel such a mistake?
Because for Barker, in that agitated state, the shovel was likely perceived as both his tool for work and potentially a defensive object. By physically trying to seize it, the officer forced an immediate physical confrontation where one might not have been necessary. It instantly escalated from verbal conflict to physical struggle.
So the alternative would have been?
Maintain distance. Use communication that acknowledges his frustration, even if you don't agree with it. Something like, okay, I understand you're upset right now, but for safety, I need you to just place the shovel down on the ground. And definitely call for backup to establish scene safety before trying to physically engage someone who is agitated and holding a potential weapon or tool. Instead, the officer seemed to force a premature physical resolution.
So both the Blaine case and the Barker case really drive home the same point from the sources, don't they?
They really do. Lawful authority to act doesn't automatically mean that swift, forceful action is the best or most professional action. The professional duty, especially when dealing with people who are agitated, maybe non-compliant, but not posing an immediate deadly threat, is to prioritize prudence, distance, communication, and time over forcing an immediate physical outcome.
Okay, so we've seen the problems in oversight, the gaps in training, the legal complexities for civilians, and the tragic outcomes when de-escalation fails. Looking forward, what do the sources suggest as pathways for improvement? There have been legislative attempts, right?
Yes, there have been attempts, though the sources acknowledge that creating uniform national mandates is really difficult politically and practically. For example, they mention a failed federal bill, H.R. 5221, from back in 2016.
What did that bill try to do?
It aimed to establish a national standard for the use of deadly force, and importantly, it sought to mandate de-escalation as a required alternative before resorting to force, mirroring policies already in place in cities like Seattle. But it didn't pass.
So national legislative change is slow, maybe unlikely in the short term. Are there other blueprints available?
Yes. PRF's 30 guiding principles on use of force is often cited as a really strong, actionable framework that departments can adopt voluntarily. It's built around the core principle of the sanctity of human life. This is where many reform advocates say departments need to focus their internal policy pressure.
Can you give us the highlights? What are some key takeaways from those 30 principles?
Sure. They include really concrete mandates. Things like dedicate equal or even more training time to de-escalation and communication skills compared to firearms training. Explicitly mandate the use of time, distance, and backup as primary de-escalation tools whenever feasible.
So embedding those tactics into policy.
Exactly. And crucially, they stress establishing a clear duty to intervene. This means requiring officers to actively step in and stop a fellow officer if they witness them using excessive force.
That seems vital for internal accountability.
Absolutely. And another core principle is training officers to consciously create a zone of safety, take a tactical pause, evaluate the situation fully, and only then resort to force when it's truly necessary, having considered or tried other options.
This really connects back to accountability, doesn't it? Like the LAPD model you mentioned, where failing to de-escalate when possible can actually be a policy violation itself.
Precisely. Policy is pretty toothless without consequences. When a department like LAPD can issue an official administrative disapproval or find an action out of policy, specifically because de-escalation wasn't attempted, it sends a powerful message. It makes de-escalation a mandatory professional skill, not just a nice-to-have option that can lead to retraining, demotion, or other real disciplinary actions.
Okay, so that's the police side. Better policy, better training, real accountability. But the sources also seem to really emphasize that reform can't just be one-sided. There's a massive role for civilian education, too.
Yes, absolutely. Experts like Professor Thomas Griffith and others cited argue quite forcefully for a major public education initiative focused on constitutional rights and procedures, specifically to reduce civilian stress and maybe increase voluntary compliance during lawful encounters.
The idea being, if people understand the rules better, they're less likely to feel like their rights are being violated by a lawful order.
Exactly. Moving from a place of fear, confusion, and perceived violation to one of informed understanding and hopefully calmer compliance with lawful commands.
What kind of practical tools are suggested for this education?
Some interesting, quite tangible ideas came up. One proposal was equipping officers with simple, clear handbooks or maybe just brochures explaining a driver's basic rights and obligations during a traffic stop. The officer could just hand it to the motorist.
How would that help?
The thinking is, presenting a driver with a seemingly objective, official source of information right there during the stop might lessen their anger or confusion. It could help convince them that a lawful command, like being asked to step out of the car under MIMS, isn't some personal arbitrary attack, but standard procedure based on law.
That's an interesting idea.
Yeah.
And this education shouldn't just start when someone gets pulled over, right?
No, the argument is it needs to be systemic, starting much earlier. Recommendations include implementing mandatory education on basic must-know rules of criminal procedure, things like the MIMS rule, the right to remain silent in middle school or high school civics classes.
So every citizen understands these fundamentals before they even start driving.
Right. Ensure a baseline understanding of obligations, like the requirement to exit a vehicle upon lawful command and the actual scope of Fourth Amendment rights during a traffic stop.
And the DMV could play a role here, too.
Yes, that was another suggestion. Integrate basic criminal procedure rules relevant to driving into the written driver's license exam. Maybe include hypothetical traffic stop scenarios and questions about proper responses in the study materials.
So you'd literally have to learn this stuff to get your license.
Exactly. It forces every licensed driver to actively engage with and hopefully internalize the boundaries, both their rights and the officer's lawful authority. The goal is to diffuse that common conflict point we identified around the MIMS ruling before it even arises on the roadside.
So it's really about practical safety through education. If a civilian knows that arguing about getting out of the car is legally futile and potentially dangerous,
it removes that battle of wills trigger point right away. It potentially prevents the situation from escalating into the kind of tragedy we saw in the case studies. Educating the public becomes just as critical a part of systemic de-escalation as training the officers. #tagoutro. So to try and synthesize this really extensive discussion, the path towards making these police-citizen encounters less risky seems to rest on, well, three essential interconnected pillars based on our sources. First, you need that empowered civilian oversight, independent, proactive, with real teeth, real disciplinary authority.
right, the accountability piece.
Second, you need mandatory reality-based de-escalation training for officers. Training that truly prioritizes communication skills, using time and distance strategically, over just defaulting to immediate force.
The training and policy piece.
And third,
systemic civilian education, making sure the public actually understands their core constitutional rights regarding recording, the nuances of resistance, how to invoke silence, and critically, the rules of compliance during common interactions like traffic stops. This reduces that preventable friction. So oversight, training, and education, all working together.
exactly. And what the sources ultimately demonstrate is that while officers certainly have a legal right to use force in specific circumstances, that's the lawful standard from Graham v. Connor, the deeper ethical and public safety question is different. It's whether they have the necessary training and whether their departments have the necessary policies and culture to avoid needing to reach that point of using force whenever possible.
So if training can effectively teach officers to slow the action down and prioritize prudence, what responsibility does that then place on us, on communities, to really push for and support policies that incentivize that kind of restraint over just reacting with swift, immediate force?
That's the final provocative thought the sources leave us with. It's a vital and complex question impacting safety and justice for absolutely everyone involved.
Indeed. Well, thank you for helping us navigate all that complex source material today. And thank you, our listeners, for joining us for this deep dive. If you appreciated this deep dive, please do subscribe, like, and maybe leave a comment to share your own insights.
Thank you for listening to VSOW.